Aye, we give you the facts. It's not what you think. Popeye Newsling, Young King, 1 yard, bless.
Good morning, Popeye. Grandma watch Popeyes every morning and every night.
Greetings, viewers and subscribers. So today, we are going to be continuing our conversation with our in-house immigration lawyer, Mrs. Esther McKitty Griffin. Esther has been practicing as a lawyer for over 10 years. She's a partner in the law firm Griffin and Griffin LLP. They are based at Glen Burnie in Maryland. Throughout the video, I'll be posting Esther's email address, the website for the law firm, as also the contact number. For persons who had sent Esther WhatsApp messages and didn't get a response, please send the questions again. There was an issue and all the messages were lost. If you have any questions that you want Esther to answer on this program, please send your questions to 876-343-1034. That's 876-343-1034. Please send written questions. Do not send voice notes or do not call. Esther will be answering your questions free of cost on the program now. If you want to follow up with Esther on any matter, please note that there is a consultation fee. Once you tell her that it was Popeye who directed you to her, you are guaranteed a 25% discount. Remember now, hit on the love button from now, as also share the video. So let's continue our conversation with Esther. I am married to a green card holder. How does the spouse go about traveling to the United States?
Okay. So if you're in Jamaica,
Yes.
you don't have a visa, but your spouse is in the United States and they have a green card and they have filed for you or about to start the process, it's going to be difficult for the person to get any kind of temporary visa, like a visitor's visa or a student visa, because the U.S. Embassy is going to assume that you won't come back. So
Okay.
you're going to stay in the U.S. with your spouse, because that is what is known as immigrant intent. Because when people go for a visitor's visa, when you go there, you try to convince the embassy, I'm going to come back, which is why you show the ties to Jamaica. You
Yeah.
show the bank account, you show the job. You're saying to them, I'm only going to visit and come back. But here you are saying to them, hey, I'm going to the USA to visit my spouse. I mean, that could very well be true. But they also know more often than not, you come here, you be like, I'm not trying to go back to Jamaica. I'm going to stay here with the person,
Yes.
So that would probably be very difficult. So it's probably just better for you to encourage your spouse to get started on filing the I-130, the petition, the form for alien relatives, so that
Yes.
you can just get here as quickly as possible.
Okay. All right. The other one is, can I file for my kids on 2 years extension, and also can I file for my citizenship whilst waiting for my 10-year green card?
Okay. So, yes, you can file for your children while you're while you're a conditional resident. A conditional resident, that's usually when you would have applied for your green card while the marriage that you're applying through is less than 2 years.
Okay.
So they call it a conditional. When they give you that green card, it's a conditional resident green card, because once you've had the green card after a year and 9 months into 2 years, they want you to apply to have those conditions removed by showing them that, yes, the marriage is still fine, things are still working. Then you get the permanent green card, which is a 10-year green card. But yes, while you're on that 2-year green card, you would be able to file for your children. However, sometimes, they might kind of wait before they process the case, just making sure that, okay, so some people file everything all up at once, file for themselves and their children overseas.
Yeah.
I'm not sure if this person may have already got the conditional green card, so they have it, yes. You can file for your children. In terms of the citizenship that they were asking about,
Yes.
you can file for your U.S. citizenship as long as you're still married to your U.S. citizen spouse and have had your residency for 3 years.
Okay.
So you'd have had the green card for 3 years and still be married to that same to the U.S. citizen spouse for 3 years. to then qualify to apply for citizenship.
Okay.
And that normally happens sometimes when the person is applying to remove the conditions for their green card, but the process and wait time is so long that they're waiting for that to happen, and 3 or more years have passed, and then they become eligible for citizenship, so they go straight for citizenship.
Okay, understood. All right, somebody is saying, I had a DUI in 1993 in Atlanta. How can I get it expunged? Can it affect my petition for my green card?
Okay, so generally there are 3 types of crimes that will prevent you from getting a green card. Crimes of moral turpitude that I spoke about earlier, kind of like things like fraud and stuff like that.
Yes.
And the second type is like drug crimes, and then you have like aggravated felonies, right?
Yes.
Now, generally, DUI crimes don't fit any of these categories unless you seriously harm someone in an alcohol-related car incident. Usually, you know, when what did this person say? Can you
the person said, can I get it expunged?
Okay.
And can it affect my petition?
Okay,
Yes.
so that they can.
Yes.
Right. And so the same thing I said before, they're going to get it expunged. They need to keep a copy of it.
Yes.
Because immigration is going to want to know more about it.
Yes.
And sometimes they want to see like a certified copy of the record. It probably won't, like you know, I said, it probably won't prevent them from getting the green card, but they may have to answer some questions, you know, about it.
About it. Okay.
But I don't know the full details of what the DUI involves, but, you know, generally speaking,
yes,
you know,
okay,
at the shallow end of the pool, that's what would happen.
All right. Someone is saying, I'm a U.S. citizen. I'm a U.S. citizen, and I have a 5-month-old baby with a Jamaican woman. How do I acquire U.S. citizenship for my daughter?
One thing I would want to know is this U.S. citizen living in the United States, or are they living in Jamaica? Because you have, for example, you have some persons who are U.S. citizens.
Yes.
But they've been living in Jamaica their whole lives.
Yes.
There are some restrictions with that in terms of when it comes to filing petitions for your relatives if you've been outside of the country for the majority of your life.
Okay.
So that's one thing. However, when it comes to children who are born to parents who are U.S. citizens, the child is in Jamaica, there are some criteria that has to be met, but at the crux of it all, they'll be able to apply for what is called a consular report of birth abroad.
Okay.
And that application is normally submitted at the consulate in Kingston. The mother of the child would also have to sign off on some of the forms. That's something I could help them to do.
Okay.
But there are some more things I would need to know to kind of make sure everything, you know, lines up.
Okay.
But generally, yes, there are some children who are born to U.S. citizen parents. Yes, they'd be able to get what is called a consular report of birth abroad.
Okay.
Because they would have gotten citizenship at birth.
At birth.
Some children get citizenship at birth. Some get it after. So they either acquire citizenship at birth or they derive citizenship after birth. So those are the 2 ways.
All right. Someone else is saying, I have a son living in the States. He's going to be 21 soon and he's going to file for me. But my concern is I have 2 more kids. They're under the age. And I know he can't do paperwork for them. But I don't want to leave them behind because I have no one to leave them with. What should I do in this situation? The children are 16 years old and 10 months old. The person is asking what can be done.
Okay, well, I mean, if there's no one in Jamaica willing and able to care for her minor children, they could probably try to request what is called humanitarian parole on their behalf.
Yes.
And that's really a request asking, the request is made, it can either be filed here in the U.S. or filed in Jamaica where you, when it's filed here, then it gets sent to the embassy if it gets to that point where you're saying, for humanitarian reasons, this person needs to be able to enter the United States.
Oh.
They are not eligible for certain types of visas, but they need to come here. For example, I'll give you another example. Sometimes you'll have a person here in the United States who is going to do a very serious surgery.
Yes.
And the only family member who can help them after this surgery is somebody outside of the country.
Okay.
That's one way. For example, people apply for humanitarian parole and they get paroled into the country to come and help this family member.
Yes.
That's one option that this person could probably look into.
Okay.
Some people sometimes, they come here on the green card, they get the process goes through, and some of them look into a reentry permit, where it's kind of like they seek permission to stay in Jamaica for a while with the children until they can finish. They themselves can then turn around and file for the children and then bring them up a few years later.
Okay.
So it kind of depends.
Okay.
Yeah, it kind of depends. But that's also another option. Most people don't really want to go for that.
Yes.
They kind of want to be able to just come here and settle.
And settle with it. Yes,
so in that
yes.
case, they may have to look at humanitarian parole.
Okay. All right. Another question. 25 years ago, I got into some problems with the law. I received 4 years in prison. I served 2 years and was deported back to Jamaica. I have only one daughter. She's living in the United States. She filed for me 2013. I didn't receive the visa, but the embassy didn't turn me down. They said too much time has passed before we submit the paperwork that they have asked for. In 2021, she refiled the paperwork, and on the 3rd of March 2023, we received a letter stating that it is at the NVE department. Please, can you advise me what to expect? I am a 55 years old mother and grandmother. Thank you.
Okay. So the first part of that case, when the daughter files for this mother, once she files a petition. Once that petition gets approved, it goes to the NVC, the National Visa Center.
Okay.
The National Visa Center handles all the paperwork before the case gets sent to the local embassy of the country where the person is from. In this case, it's going to get sent to Kingston. So the NVC, they give you an invoice number, case number, and you're able to, follow your case online. That's where you submit all the paperwork. So she would submit in her case, her criminal history, her daughter's birth certificate, and all those other documents. Once they review everything and they declare that she's documentarily qualified, which means all the documents they need, they have it. They will schedule her for an interview with the consular officer in Kingston.
Yes.
At the interview, they'll ask her about that criminal history and, other things.
Okay.
Hearing what you've said so far, this is the kind of thing she should get an attorney to help her with.
Yes.
Because whatever the issues are, which, she didn't say, but she would definitely have to have an attorney go through it with her to see where those situations or issues, where they fall, how serious they are. Because if it is that they are pretty serious, they are probably going to say she needs a waiver.
Yes.
And in her case, she may not even qualify for a waiver. So she needs an attorney to kind of let her know where she stands before she gets to the interview.
Okay. All right, another one.
Not everybody.
Yes, go ahead.
I was going to say, even though the embassy may say you need a waiver, not everybody qualifies. For one. And that's kind of what's sad, But go ahead,
Yeah, okay. I used to live in the United States. I am married, put in my paperwork, but I fly back to Jamaica before I got my green card. Before I was called for an interview, but they sent me back to Jamaica, so I overstay my visa. What can I do?
Okay, I'm thinking what happened is the person was here, they overstayed.
Yes.
They got married. They filed the paperwork. While the paperwork was processing, they left and went back to Jamaica.
Oh, yes.
And they tried to come back.
Yes.
And they turned them back because
they had overstayed
their visa.
Yes.
That's what I'm probably thinking happened.
Yes, exactly.
You can't do that. When you would have filed here, the green card application is called the form I-485. When that form has been filed with USCIS, you have to remain in the country while that form is processing. If you leave without travel authorization, it would have been deemed that you abandoned that application.
Yes.
And once you abandon it, now you're going to have to reapply for your green card at the embassy in Kingston.
Okay.
Which means your spouse who is here in the United States would have to then send a message to the NVC. There's a certain form that is filed to let the NVC know, okay, the person is now in Jamaica and we want to now do consular processing to bring them back up here.
Mm-hmm.
However, because they have overstayed their visa, they're probably going to need a waiver.
Oh.
So it actually makes their case a lot more complicated.
Okay.
Which is why if you're here, you've overstayed, your paperwork has been filed, it's good for you to apply for travel authorization. That way, if there's an emergency, you need to travel, you need to go to Jamaica, you use the travel authorization to go and come back, and your case will still be pending without a problem. Without the travel authorization, everything becomes basically null and void, and you now have to start consular processing while in Jamaica.
Explain travel authorization. I hear you using that term. Yes.
So the travel authorization is also it's called advanced parole.
Mm-hmm.
And so remember I talked about humanitarian parole earlier?
Yes.
So this is a different type of parole. This is what it's called, advanced parole. And basically you apply for it for, basically you're asking in advance.
Yes.
You're saying, in the event I have to travel, will you grant me a document that will allow me to be paroled back into the country? Because remember, you would have overstayed, so you actually have no right to come back in after you have left.
Yes.
But because you would have applied for, quote unquote, pre-applied for parole, you have this travel authorization document now that allows you to come back into the country.
Okay.
So usually when I do the green card applications for my clients, I also do advanced parole, and I always say to my clients, this is for emergency only. It's not for you to go on a cruise or to go to Jamaica and go show all your friends and say you can travel now.
Yes.
This is for if something terrible happens.
Yes.
It's a loss of a family member. Somebody's extremely ill and you need to go. Because the thing is, just like the visa, when you come back to the port of entry to the CBP officer, and he's saying, where were you? You're going to want to have something to say.
Yes.
I really had to travel because my mother was very sick and I had to go see her.
Okay.
Because again, they can turn you back.
Even if you have it, they can turn you back. Yes. Yes.
Yeah. You want to have a good, valid reason for why you had to travel during this time.
Okay. Got it. All right. Next question is, somebody is saying, let me see. Okay. I have a good friend who entered the USA from Canada and is living for over 25 years. She has three children. What she have to do to stay in the USA? Second question, if I travel to the USA and want to go to Canada for 6 months, can I re-enter the USA after spending 6 months in Canada and come back to the USA to Jamaica, or exit Canada to Jamaica?
All right, so the first part, so you said a friend entered the USA from Canada.
Yes.
And have been living here for over 25 years.
Yes, she has 3 children.
She has 3 children.
Yes. And what does she do? What does she have to do to stay in the US? Yes.
Right. Okay, so I'm assuming that these 3 children are U.S. citizen children.
Yes.
However, if she entered, how did she enter,
Yes.
I would have to know how did she enter the United States, because if she entered with a visa from Canada, then she would have been admitted, which then allows her, if she has U.S. citizen children over 21, to be able to file for her.
Yes.
Right? File for her LPR status. However, if she entered without inspection, which means she just came over the Canadian border to the USA, then that makes it way more complicated, and they probably would not be able to help her. But there just isn't enough information for me to kind of tell her what she may qualify for. I don't know if she has, any form of Canadian citizenship or anything. I would need to know more.
Yes.
And then the second part of the question, what did you say about traveling to the U.S.?
If I travel to the USA and want to go to Canada for 6 months, can I re-enter the USA after 6 months after spending 6 months in Canada? Basically, that's what the person is asking.
Okay. I mean, put it this way. Each country has their documents that you need to exit and enter, right?
Yes.
So if you're in Canada and you want to come directly to the United States, you need to have a U.S. visa to enter.
Yes.
If you're in the United States and you're trying to go back to Canada, you need to have a Canadian visa to go back over there.
Yes.
No, just like we talked about, I think like at the beginning, I was talking about staying, 5 months this and that. there'll be those regulations also in place. So you have to be mindful of that.
Yes.
So you could find that you're here in the United States and probably try to go back to Canada and maybe denied entry because you may have, some violated something or come too close to one of the rules they have.
Yes.
So those are the things they have to be mindful of.
Okay.
Each country has, the documents to enter and exit. So
Yes.
Canadian visa, the US visa, and you can go to and from as long as you have it.
Yes.
But that doesn't mean it's always going to be just smooth sailing, just going back and forth all the time. So you have to be mindful of how long they're traveling and when they're traveling.
All right. This is gonna be a long one. All right. And the person is saying I was deported from the USA on January 10, 2003. I was only locked up for a fake driver's license. I spent 20 days in jail, and then they turned me over to immigration in Cleveland, Ohio. I go to court. They gave me voluntary departure and a bail bond of $5,000. I came to Jamaica, but I did not report it at the airport when I was leaving. I just buy a ticket and leave. I spent some time in Jamaica. Went back to the States. They hold me 8 months after I went back. They hold me in Texas. And the immigration in Texas told me that a warrant was out for my arrest because I never leave the country. I tried to show them all my proof, but they removed me. I leave 2 kids behind, a daughter who is now 23 years old, a son who is now 21. I even stay here, work, pay my daughter tuition for college, etc. What I would like to know is if my daughter, who is now 23, can file for me, even though I have been deported, never had a felon before. The person is asking if their 23-year-old daughter can file for them.
Okay. Lots of parameters, lots of things.
Yes.
In this fact pattern, generally, an adult daughter who is a citizen can file for their father.
Mm-hmm.
He left, pursuant to voluntary departure.
Mm-hmm.
And that is when, you agree to leave without them having to physically deport you.
Yes.
And like he was saying, you have to let them know when you have left, which he didn't do.
Yes.
But he returned illegally, it seemed, and was deported.
Yes.
So his record is getting, or not getting, it is
stick
quite complicated.
Yeah, complicated. Yes.
Yeah.
Yes.
So because right now, as he was told by the judge, the U.S. government thinks he never left.
Yes. So
they might have him under some kind of permanent ban and all that kind of stuff. And he just needs a good lawyer.
Yes.
He just needs a lawyer to, he has a lot going on in that situation. There's lots of paperwork to see what are the things he was actually charged with and all of that.
Yes.
To be reviewed, to kind of see where he stands, so then his daughter can know what she'd be up against in terms of filing for him.
Okay.
Perhaps not impossible, but there'd be a lot to sift and sort.
Okay. Next question: can a U.S. citizen spouse petition for her partner if she is living with one child and is in Section 8?
So file for, so I'm guessing the partner is the husband and not somebody else?
That's what I do. Can your U.S. citizen spouse petition for her partner if she is living with one child and is in Section 8?
I'm going to assume that her use, the use of the word partner is synonymous with the word husband.
Yes. Okay.
Because, right. Because if a U.S. citizen spouse petition for the partner, that you can't do that.
Yes.
You're not married to the person, you can't file for them.
For them. Okay.
You assume she's talking about the
husband. Yes.
So she's saying she lives in Section 8.
What does that mean?
She want to file.
What does that mean?
Section 8 is government housing.
Okay.
That's government housing, and that is a problem.
Okay.
Because that petition could be denied if the government thinks that the immigrant is going to come to live in this Section 8 housing.
Okay.
They're very particular about that. They call it, if you're going to become what they call a public charge, which means you're going to be dependent on them for certain resources. So if your spouse is already, quote unquote, dependent on the government for housing,
yes,
then that already casts a shadow on your application. It could make it difficult to be because actually just recently they re-added those questions back on the form.
Oh.
They were there during Trump's time.
Mm-hmm.
They took them off, and they recently put them on about 2 months ago, where they're starting to ask, are you getting any kind of federal aid and food stamps and this and cash assistance and how they're asking these questions.
So okay.
It would be an issue.
Okay. Next question. Can a U.S. citizen spouse petition for her partner if so this would be the petitioner, if she had a felony for assault, robbery, and gun charge case that happened years ago, and she did 8 years in prison, but out now and working?
So you are saying that the U.S. citizen,
yes, had a felony charge
for the criminal charges.
Yes,
they have a bunch of criminal charges.
Yes.
Okay, if the U.S. citizen spouse has the criminal charges, it's not a problem.
Oh,
for the spouses. If the immigrant has the criminal charges, then that could stop the whole case.
Okay.
Let me add, however,
yes,
if you're dealing with a K1, a fiancé visa,
mm-hmm.
for that visa now, where you get engaged to the person and then you come here to get married, so they bring you up on the fiancé visa. In that case, they do look at the criminal record of your fiancé.
Oh.
In that case, the U.S. citizen, they do look at your criminal history.
So when is it that they wouldn't look at it? You said K1.
K1, yeah. So the fiancé visa, they would look at the U.S. citizen.
Okay.
But if it's a spouse, like this person said, they're spouse, so they're already married.
Yes.
The criminal history of the U.S. citizen spouse does not come into question.
Okay.
Only the immigrant. Yeah.
Okay.
But I just want people to just understand, however, that if they're in a fiancé situation
mm-hmm.
where they're engaged to a U.S. citizen,
mm-hmm.
and that person they're engaged to has some kind of criminal history,
yes,
then yes, that needs to be disclosed.
Yes.
And some explanation may have to be given, or we have to submit some type of records or something. Okay. But if it's a spouse, if you're already married to the person and the person has some criminal history, it doesn't come into play.
Okay. All right.
Just the immigrant.
Just the immigrant. Okay. All right. Next one. How long after getting a divorce can you remarry in New York? No papers for petition was filed.
So the divorce is finalized, which means you have an order. The judgment of absolute divorce has been given.
Yes.
So the divorce is finalized. I mean, technically, you can marry somebody new the next day.
The next day. Okay.
Theoretically speaking.
Mm-hmm.
However, USCIS will be suspicious though.
Yes.
Because when you're filling out these immigration forms, they ask about prior marriages.
Yes.
So even though you may have married somebody, but no paperwork was filed with that person, the mm-hmm. marriage just didn't work out, mm-hmm. so you divorced the person, and now you're remarrying somebody else and you're going to file paperwork, they're going to look at the dates and they're going to see, oh, you got divorced on,
mm-hmm.
June 12th, mm-hmm. 2022.
Yes.
And then you remarried on June 13th.
Yes.
Which is fine, because some people would have been waiting for a while to get divorced, and as soon as they get it, just waiting for it, they just go to the courthouse the very next day and get married again. It's fine, it's life, it happens. Yes. I'm just saying, just don't be surprised if it does, however, come under scrutiny by USCIS to say, hey, how it is you got divorced, and it's quick to turn around and getting married again. It's not impossible for them to do that.
Okay. Another one is, my question is, I have been married for 9 years in Florida, and just last year I received my green card, and we have since separated and don't live together anymore. Now, from I got it, my wife keep threatening me to go to immigration to have it revoked. My question is, I would add, can the wife get it revoked?
No.
Okay.
It's not, immigration is not going to just revoke the green card simply because the wife decides to call in and say XYZ.
Yes.
It doesn't really work just like that. It's not just like, boom, one phone call and suddenly the green card gets revoked.
Yes.
And for this particular person, you said they were married for 9 years?
Yeah, I've been married for 9 years. Yeah, 9 years, yes.
Right. So that's a long time.
Yes.
If this couple, they were married for 9 years,
mm-hmm.
and, immigration, they finally got the green card, whatever and all of that.
Mm-hmm.
I mean, just the 9 years alone is showing some validity to the relationship.
Yes.
That spouse would really have to, go through some hoops and lens to try to convince immigration otherwise. But it probably would never happen.
Never happen.
It doesn't happen just like that. It's hard, very hard to get it revoked. Very hard.
And that 9 years is a whole lot. That's not showing any fraud to me.
Yeah, I mean, it makes you wonder. Yeah, because they had a whole 9-year relationship.
Yes.
Whether good, bad, or different, it was 9 years.
Yes.
So that itself is its own testimony.
Yes.
So all of that would be, but it don't happen just like that. It just doesn't. It wouldn't get revoked. So they shouldn't worry.
Yes. Okay.
They'll be fine.
Okay. Another one. I'm living in the United. Well, this is the final question. I'm living in the United States of America. I'm living in the United States of America, and would like to know how can I file for my nephew. Both of his parents are deceased. Both got sick and passed away.
That's a sad to say. It's a pretty common scenario. A lot where you have these children where something has happened to one or both parents, and there's a relative here in the United States who wants to help.
Yes.
If they were able to get a visitor's visa for that child, or perhaps parole into the United States, then they could probably, once the child is here, there are some options that would be available for them to be able to help the child.
Yes.
Another option is if the child is under 16, they can adopt the child in Jamaica and then file for what is called an orphan petition and bring the child here as an orphan. Because in this case, both parents have passed away.
Yes.
So to this person, if the child is under 16, adoption may be the route to get the child out of the country.
Yes.
If the child, some children may already have, are able to travel. If the child is in the United States or happens to be in the United States, then there are a lot of options that, then become quite available to the person to the child at that point. So it depends. I would need to know more,
Okay.
I would kind of need to know more about that to kind of give them some guidance into what they can do. But they're probably, especially if the child is under 16, options. And if they're here, under 21 options.
Okay. We have covered a whole lot. a whole lot.
I know, right?
Yes.
I feel like I just had an exam.
Man, I tell you. I feel like I can answer any immigration question after this. Yeah, man, trust me. But I appreciate it, and hopefully, I'm gonna get some more questions, submit them to you, and we'll be able to.
Okay.
Yeah, man. Yeah, we'll be able to. But thanks a lot. It was really a pleasure talking to you. And
thank you for having me.
Yeah, man.
It was an honor.
Yeah, man. And we'll talk soon.
Thank
Blessed love, everybody.